Hey everyone, my name is Kelly O'Connor. My pronouns are she, her, and I am the Training Institute Director at the Maine Coalition to End Domestic Violence. I am delighted to be here with my colleague, Andrea Mancuso. We're going to be talking about protection from abuse orders as part of Module 5 for the Maine Victim Assistance Academy. Andrea.
Good morning, everyone. My name is Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence. I've been with the coalition for a little over 4 years, and prior to that, I spent a number of years as an attorney working to represent survivors of domestic violence and sexual assault in civil court, including in protection from abuse cases. And the protection from abuse statute is one of my favorite laws. Last year, together with Melissa Martin from MICASA and Lucia Hunt from Pine Tree Legal Assistance, we wrote the whole statute to hopefully make it clearer for survivors and for all of you who are helping navigate survivors through the process. So it's one of my favorite topics to chat about and provide support around. And so I'm delighted to be here talking to you all today about protection orders.
Thank you so much, Andrea. So I'm going to start with one of the first questions that came through from folks in that responded to the survey that we sent out. Thank you again to everybody who did send your questions into the survey around all things protection orders. We're going to get to all of them in some fashion throughout this, but really let's go to basics. Like, what is a protection from abuse order?
The protection from abuse order is a civil court order that's designed to protect and support survivors of domestic abuse and violence, survivors of sexual assault, stalking, trafficking, who need immediate protection and support in order to keep themselves and their children, if they have any children, safe. It's one of the only ways in our state that a person can obtain a court order without first giving the other side a chance to be heard. It is a case that is started by the person who has been abused filing a document called a complaint with their local district court and asking the court for what relief they feel like they need in the immediate term. And the parties to the protection from abuse case are the plaintiff, who is the person who's alleging they've been harmed, and the defendant is the person who is alleging who is being alleged to have perpetrated the harm.
So what's the difference then in a temporary protection from abuse order and a final protection from abuse order, or PFA?
So temporary order is really meant to only be in place for a short time until a hearing can be held where both the parties, again, the plaintiff and the defendant, can be heard by the court, and a court can decide what to do. Because a temporary protection order can be issued to a plaintiff based only on the plaintiff's complaint and the plaintiff telling the court what has happened without giving the defendant a chance to be heard, our laws require that the court schedule a hearing on a protection from abuse complaint within 21 days. Generally, a temporary order will only be in place for that couple of weeks or a few months, depending on circumstances, if the court case needs to be continued for any reason. A final protection order is one that issues either after the court has held a hearing and made findings that abuse occurred and a continued order is necessary for the protection and support of the harmed person, or is issued by consent of both parties, the plaintiff and the defendant. And that final order can be issued for up to 2 years with a little asterisk, because if the person seeking a protection from abuse order thinks that they need more than 2 years of protection, even though that first time around, the court only has the ability to order a 2-year order, if they need continued protection, they can file a motion to extend the order as the expiration of that first order gets closer, and at that point the court has the authority to extend the final order for as long as they feel like is necessary given the circumstances of the case. There are a couple of differences between a temporary order and a final order in terms of what kind of relief the court can give. Firearms can be relinquished in either. We're one of those states where firearms can be ordered relinquished in a temporary order and in a final order. Orders regarding care and control of any common children can also be part of both temporary orders and final orders. Any financial orders, child support, spousal support, things like restitution or payment for lost wages, can only be issued as part of a final order. None of that relief is able to be ordered by the court in a temporary order.
Okay, that's really helpful. Thank you. So, doing advocacy, when I worked at one of the DV programs in the Mid-Coast, I often experienced victim survivors who may have both been involved in, had a criminal case going on against the person who had harmed them, and also were considering a protection from abuse order. And I often found many survivors confused about the difference in a protection from abuse order and conditions of release. Like, what are the differences in the two, and how, so we can best describe those differences to victim survivors that we're working with, and what are the pros and cons for a protection order and conditions of release?
That's a great question, Kelly. There are several differences in protection from abuse orders issued out of civil court and conditions of release issued out of the criminal court. A couple of limitations around conditions of release is that they can't really thoughtfully address parental rights issues, which are often of immediate concern to victims where there are children, particularly children in common. They also cannot address really economic support issues. And I'll say it's appropriate that conditions of release don't address these issues. These are issues that are not the focus of the criminal prosecution, which is in fact the state versus the defendant, not the person who's harmed versus the defendant. And for these issues in particular, the person who has harmed really needs to be able to be in the driver's seat to weigh in on what really are critical issues for how they navigate through their days. And that's really not possible in a criminal proceeding where they're not a party and really have no standing to be heard. Protection orders issued out of civil court can deal with children and critical economic supports. They're also for a definite period of time. Right? You're going to have that final order issued. It's going to have an expiration date, whereas conditions of release really track the pendency of the criminal case. And so when that criminal case wraps up, the conditions of release drop off. There's no criminal case there to hold them. In a protection order, a survivor knows when that order is going to expire. Notice is also a really key difference to think about. When a defendant wants to change the terms of a civil protection order, the plaintiff is required to get notice and an opportunity to be heard. That motion will be scheduled. The plaintiff will get a notice of when that motion will be scheduled for. It really won't be like the next day or within that week. It'll be set out a little bit. They'll have an opportunity to think about whether or not they want to hire an attorney to come in and help them respond to the defendant's requests. On the flip side, conditions of release can be modified with really little to no notice to plaintiffs. And again, plaintiffs really have no standing in these cases. There are some advocacy considerations too, in terms of trying to help a survivor figure out what is the right path for them. Is it relying on conditions of release? Is it relying on a protection from abuse order? Is it having both in place at the same time? And that's really an opportunity for some collaboration between the DA's office, and often the victim witness advocates in the DA's offices, and the community-based advocates that are more commonly taking the lead around protection from abuse cases, right? There are some considerations there. A survivor, particularly a survivor who doesn't have children in common with a defendant, or doesn't really have a need for ongoing economic supports like child support or spousal support, may very well be able to rest upon the bail conditions for a while. But if they have real significant safety considerations and a desire to keep that person away from them for a longer period of time, that's often it's easier for a survivor or victim to say, I'm going to rely on the bail conditions if they have some level of confidence that there'll be some communication when those bail conditions are likely to go away, such that they can pivot into the protection from abuse process in a way that leaves no gap between them having court-ordered protection. The other thing to really consider is for victims who may not need some of the more family related pieces of relief, like financial support or orders concerning their children, or possession of the marital home, for example, is the extent to which pursuing a hearing in a protection order case could have implications on the criminal court prosecution. Right. So if you have a defendant who's represented in the criminal case by a defense attorney, and that person's showing up in the protection order case, it's not uncommon for that protection order hearing to be used essentially as a deposition for a crime victim. So there's a lot of reasons, both for the safety and well-being of the survivor, and also implications for the criminal prosecution, why really a best practice would have whomever's helping that survivor in the civil court context, and whomever's helping them understand what's happening in the criminal case, really having some thoughtful communication back and forth about how best to support the survivor's needs.
Yeah, I think that's one of the key goals for the Academy, is to enhance collaboration and coordinated community response between our systems-based advocates and our community-based advocates, both our sexual assault and DVRC and tribal advocates. And I've appreciated sort of how you laid out how the two processes sort of interact. And one of the things I'm hearing, the way you talk about the pros and cons of each, is that, like, should, after some advocacy work, an advocate be working with a survivor and they decide that, like, it's a safe option to pursue a protection from abuse order, there's a lot more agency involved over that process than there is, of course, with a criminal case for a victim survivor when there are conditions of release.
And I think there's opportunities there for the district attorney's offices to support a little bit more agency of victim survivors in weighing in on what the appropriate conditions of release are. You know, one example that really stands out for me that I used to experience quite frequently representing survivors is we might go in with a civil case that might be the first court case, right? The criminal case might not come in until the defendant violated the protection order that we got in civil court. And there's a benefit for the criminal court in those circumstances to really have an idea of what the civil court order says and how that is or is not meeting the needs of the survivor who obtained, right? So, for example, in a protection order case, it's not uncommon that you could deal with sort of extensive property retrieval language, right? You've set up when the defendant can return to the marital home, like when, under what conditions, like who can accompany them, what they can take. And then if they violate the protection order and there's a criminal court case and someone in the criminal court conditions of release checks the box that the defendant can return one time with police for property retrieval, that order doesn't have these same conditions, and that causes some level of confusion and disruption when the survivor's trying to then navigate with law enforcement. But really the property retrieval should look like it's laid out in my civil court order. Which order do you follow? And that really causes some consternation for law enforcement because there's some level of conflict between those orders. I think we also see potential for conflict around if there's any prohibitions on contact with children, right? So if you have carefully negotiated some contact and visitation in the civil protection order, that's probably for a reason. And then if the criminal court comes in and just prohibits all contact entirely, that might be what the survivor is looking for. But to do it summarily without really having a conversation about what orders would be helpful and what orders might not be helpful is really important. And again, that collaboration piece between the supports that are helping in the civil court process and the supports that are there for the survivor in the criminal court process. Collaboration amongst is really important.
Yeah. So who then is eligible to ask the court for a protection from abuse order? What's the eligibility look like?
For that, we should probably open the statute and take a run through because it's broad and also detailed. So
Great.
I will just share my screen. And before we go through sort of eligibility, I think it's important to understand some of the key definitions in the protection from abuse statute. And Kelly, can you see my screen?
I can, yeah. I'm just gonna move the captions so we can see it better. So I moved to the top now.
Great.
Yeah,
so the definition of abuse is really important in the protection order statute. The definition of dating partner and family and household members are really important to understanding eligibility for protection orders and what types of conduct certain folks are eligible to petition the court for protection around. So abuse means attempting to cause or causing bodily injury or offensive physical contact. This includes all of the sexual assaults under Title 17A, except for what is known as parental discipline. Attempting to place or placing another in fear of bodily injury, regardless of the intent of the perpetrating party, through any course of conduct, including but not limited to threatening, harassing, or tormenting behavior. Compelling a person by force, threat of force, or intimidation to either engage in conduct which they have a right or privilege not to engage in, or not to engage in conduct that they have a right to engage in. Knowingly restricting substantially the movements of another person without that person's consent, either by removing that person from their residence, place of business, or school, or moving that person a substantial distance from where they were found, or confining the person for a substantial period, either in the place where the restriction commences or where they have been moved to. Not allowing a person out of the room when they want to leave the room is something that would really commonly fall under that paragraph. Communicating to a person a threat to commit or causing to be committed a crime of violence dangerous to human life. Repeatedly and without reasonable cause following the plaintiff or being at or in the vicinity of plaintiff's home, school, business, or in place of employment. The repeatedly and without reasonable cause are important qualifiers there. Engaging in unauthorized dissemination of certain private images. This is often referred to as the revenge porn component. Engaging in aggravated sex trafficking or sex trafficking as described in the criminal code. So that's the abuse definition. You can see it's pretty broad. It covers a lot. And then we're going to get into how we define certain sets of people. So dating partners means individuals currently or formerly involved in dating each other, whether or not they are sexual partners. It's pretty broad. Right? The court has the ability to really determine whether or not the relationship that's being articulated falls into that bucket of dating partners. And family or household members is also a really important definition in the protection from abuse statute. And so it means present or former spouses or domestic partners, individuals presently or formerly living together as spouses, parents of the same child, adult household members that are related, either by consanguinity or affinity or blood or marriage. Minor children of a parent or guardian when the defendant is an adult household member of that parent or guardian. Individuals presently or formerly living together, and individuals who were or are sexual partners. And you'll see there's some level of overlap in these categories of folks. Then we move down into eligibility.
Okay.
And this will look a little bit different than what some of you have maybe seen in the past. And particularly for those of you who've been doing this work for a really long time, the statute was just rewritten. This is a new section of the statute. It doesn't change the law in any way. It just provides some level of clarity around who is eligible, because that is it's a challenge that particularly survivors of sexual assault and stalking would have trouble accessing the protection from abuse statute the way the statute was previously laid out. So the eligibility is broken out into, are you sort of just a generic adult, eligibility for minor children, and there's a special eligibility category for older or dependent adults. So as we're looking at, if you're an adult and you're trying to get access to the protection from abuse statute, how do I know if I qualify? If you are an adult who has been a victim of abuse, any of the category of stuff that we just looked at, by a family or household member, so you're going to fall into one of those family or household member categories, or a dating partner, or if the person who has harmed you is related to you at all, right? You fall into that abuse bucket. We have some additional categories regardless of what your relationship is to the person who has harmed you, right? And so that's going to be stalking, any sexual assault crime. That's the crimes that are in Title 17A, Chapter 11. It's the range of sexual assault crimes. Any crime described as unauthorized dissemination of certain private images. So if you're a victim of revenge porn, you qualify for seeking a protection from abuse regardless of the relationship between the other person. And conduct described as aggravated sex trafficking or sex trafficking. And so the new statute makes it really clear that for the purposes of this particular paragraph, the conduct does not need to have been perpetrated by a family or household member, dating partner, or someone who is related to you. So that 1 through 4 really is entirely regardless of relationship. Minor children are eligible for protection orders for much of the same conduct. There are a couple of additions, and there you'll see those in subsection 5 and subsection 6. So conduct that's described as sexual exploitation of a minor or dissemination of sexually explicit material, right? Those and also harassment by telephone or electronic communication device as referenced in Title 17A. And then as we go down to older dependent adults, this is a piece that used to be very hidden in the old statute. And so hopefully moving it here into this eligibility section will make it clearer the types of conduct that older dependent adults could actually come in under the protections of the Protection from Abuse statute. So they're really looking at folks that are 60 years of age or older, or a dependent adult as defined in Title 22, or an incapacitated adult as defined in Title 22. So those have very specific definitions. Who has been a victim of abuse as defined earlier in this chapter, and also as defined in Title 22 by an extended family member or an unpaid caregiver. Right. And so the adult victim, their legal guardian or representative of the department may seek relief on their behalf. So that's sort of eligibility in a nutshell. So minor children are eligible to be plaintiffs in a protection from abuse case. They can't do it on their own. There has to be an adult has to file on their behalf. Is sort of the caveat there. But if you have a child who is essentially the person who has been abused or comes under the category of non-abuse conduct that qualifies, they can get an order. They just need an adult to file on their behalf.
That's great. Thanks for showing us the new statute. It's very exciting that was recodified. And I do hope that it will make things easier both for victim survivors and also advocates that are, supporting them through this process.
Here's hoping.
Yeah. So we looked at the eligibility, sort of who, and the definitions of what constitutes abuse. But what about the relief? What kind of relief can a protection from abuse order provide? I know we started to look at some of the economic pieces and the differences between conditions of release and the PFA, but could we go through more specifically what kind of relief a plaintiff can ask the court for support with?
Yeah, I'll just go and share my screen again. Okay, so there's a lot of relief that is available. And that's really because the purposes of the protection order statute are not only to tend to the physical safety of the person who has been harmed, but also to try and sort of allow them to move forward in a way that is free from abuse. And sometimes that really takes a lot. And so we want the courts to be able to look at the individual circumstances of the folks that are in front of them in this particular case and determine what is needed to sort of, in the short term, tend to the safety and overall well-being of the person who's been harmed. So we'll also talk about in this section those pieces of relief that are enforceable by law enforcement and the criminal legal system when violated, and what makes a person eligible to be charged with violation of a protection order as a criminal charge, and those pieces of relief that are not eligible for really law enforcement to arrest and the criminal legal system to charge, but are only enforceable through a civil contempt process. So the first is a basic order that the defendant not commit any crimes against the person, right? Don't threaten, assault, molest, harass, attack, or otherwise abuse the plaintiff and any minor children residing in the plaintiff's household. To direct the defendant not to possess guns, dangerous weapons. To prohibit the defendant from use, attempted use, or threatened use of physical force that would reasonably be expected to cause bodily injury against the plaintiff or a minor child residing in the household. To keep the defendant away from the plaintiff's residence. To prohibit the defendant from repeatedly and without reasonable cause following the plaintiff, being at or in the vicinity of their home, school, business, place of employment, and to prohibit them specifically from engaging in conduct defined as stalking. Now, these are all criminally enforceable with a violation of a protection order charge if a person engages in this behavior. Many of these are also independently crimes in and of themselves, right? So if a person has a protection order in place that says, don't threaten, assault, harass, don't stalk, and the defendant engages in that behavior, they could be subject not only to violation of protection order, but also to be charged with assault, with criminal threatening, with stalking, in addition to the violation of protection order charge. Directing the defendant not to have any direct or indirect contact with the plaintiff, including via social media. And that's defined in the protection order statute, that term social media. When the parties live together and is joint, joint ownership, jointly leased, the court can grant temporary possession to the plaintiff of the premises. So I live with my husband, and in addition to prohibiting him from coming back to the house, there's an order that also gives me possession of it, and that can really be helpful for renters as well. Directing the defendant not to injure or threaten to injure any animal owned, possessed, leased, kept, or held by a party or their minor child in the household, right? So it doesn't have to be my dog. It could be our child's dog, right? But because the child is a minor residing in my household, the order could also protect my child's pet. And then we get down to parental rights. Right? So the court has the ability to order sole parental rights, shared parental rights, allocated parental rights, however the court determines that parental decision-making should be in the short term. They have the ability to do that. They should use the family court code, the best interest factors in determining what parental rights and responsibilities orders are appropriate. Importantly, it's not binding on the family court. So when the parties get to family court, whatever the protection order court has ordered in a protection order should be reconsidered entirely again by the family court. And that's sort of a recognition that these protection orders are summary processes, right? You're going into the court, you have a limited window, both of hearing time and to prepare your case. And so the family court is supposed to then sort of take it up and move it forward in a longer term. With respect to the unauthorized dissemination of private images, the court can really enter any orders determined necessary or appropriate. And so there's an inclusive list, but this is not the only things that a court can order with respect to trying to ameliorate what has happened. So they can prohibit the defendant from disseminating private images. They can order the defendant to remove, destroy, return, or direct the removal, destruction, or return of the private images, right? If they've already disseminated them, they can put the obligation on the defendant to take care of how they're being disseminated. And they can order the defendant to pay any costs associated with removal, destruction, or return, right? So if the defendant has forwarded to a party that is saying, well, I'm only going to take them down if you give me $200, or like there's a cost here, maybe litigation costs, because you have to then go and engage in civil court litigation against the person who's disseminating them. All of those costs can be associated to the defendant. And so those are going to be the ones that are criminally enforceable, is this top of the list here. As we move down the list, we get into those things that are only really enforceable through going back to court and asking the court to hold the defendant in contempt and make any other orders that they determine necessary. So this is where we're talking about a division of personal property and household goods, placing any protection orders, including telling the defendant you can't take this property, you can't sell it, you can't destroy it. The court really has some flexibility there, and that's going to be sort of temporary orders, typically. They can order the termination of any life insurance policy or rider if the defendant has a life insurance policy over the plaintiff. You can require the defendant to attend a certified domestic violence intervention program, to receive counseling from a social worker, a family services agency, a mental health center, psychiatrist, or to really participate in any sort of supportive service that the court thinks is appropriate to trying to prevent further harm or address the conditions that resulted in harm in the first place. Ordering the payment of temporary support, right? So we have in this protection order statute the ability for the court to order both child support and spousal support, right? And I think spousal support is even more rarely ordered than child support as a practical matter. But these have both been in the statute for a really long time. They're there and often very important to a plaintiff's short-term economic well-being. And so it's a real advocacy point for folks that are working with survivors in navigating these processes and preparing to go to court and preparing to ask the judge for what they need, to know that this is available to them to help their short-term economic stability. And to prepare a survivor for, what does that look like? How can you help yourself make those asks? There's also this lovely paragraph here that also creates some pathways to financial relief, right? So the court can order payment of monetary relief to the plaintiff for any losses suffered as a result of the defendant's conduct. That's pretty broad. Right? It includes, but is not limited to, loss of earnings or support, reasonable expenses incurred for personal injury or property damage, transitional living expenses, reasonable moving expenses. An important piece here that is underutilized, but really important to know about, is either party can ask for the court to set a later date on the issue of monetary relief, right? So if you have working with a plaintiff who has experienced extensive property damage or has an awareness that they're going to have unreimbursed medical costs, anything that they're not really clear on in the moment, or if they're feeling like they don't have enough information to make the ask of the court at that initial hearing, they can ask the court, I really want to ask you for monetary relief under this paragraph to cover things like my property damage and my personal injuries or my moving expenses. I'm going to need to move, but I don't know how much it's going to cost me yet. I'd like, to set a date out 30 days from now to come back and be able to present you with additional information and ask for that monetary relief. And that's available to either party. Ordering the defendant to pay court costs or reasonable attorney's fees. The court can only order the plaintiff to pay court costs or reasonable attorney's fees if a judgment is entered against a plaintiff after a hearing. So if the court is saying, I'm not finding that there's any qualifying misconduct here from the defendant, and the court finds that the plaintiff filed a frivolous complaint, right? That there was really no basis for the plaintiff to have thought that this was a reasonable step to take. They can direct the care, custody, or control of any animal owned, possessed, leased, kept, or held by either party or a minor child resulting in the household, right? So the pet piece up here was ordering the defendant not to injure or threaten. The piece down here is really ordering who gets to have care, custody, and control over that pet. They've got some protections here designed to respond to folks who are accessing the statute as a result of sex trafficking. Entering any orders determined necessary and appropriate, including requiring the defendant to pay economic damages related to the return or restoration of the plaintiff's passport or other immigration documents, and any debts of the plaintiff arising from within that trafficking relationship. So it's pretty broad and meant to sort of right in the short term address. I think that's also a not frequently used or relied upon piece of relief. And then there's this wonderful sentence at the bottom that says entering any other orders determined necessary or appropriate in the discretion of the court. And this is where really you can ask the court for whatever the plaintiff needs, right? They can come into court and say, in my circumstance, this particular thing is what I need to be safe, or I need this not to happen. And the court has the discretion to say any other orders that I think should be reflected here in order to properly tend to the broad purpose of this statute and the purpose of the proceeding, and enter those orders. That's quite a lot of relief. I think we just spent like 12 minutes just going over the types of things that the court can order. It can be overwhelming. It can be overwhelming for litigants to have a full understanding of what is available to them. It can be overwhelming for a court to have to think about what of all of these things is appropriate here. It can be overwhelming for defendants, quite frankly, to have an understanding of what orders they could be subject to. The fact that some of them are enforceable through law enforcement and criminal consequences and some of them aren't is also quite frequently a point of confusion. The statute, at least now, does have sort of a nice sequence, so you can drop down to a certain portion of the statute. It tracks with the court's forms for the most part, and the court forms, the protection from abuse order form that is currently being used by the courts, which we can pull up. Grab that.
Great. It's nice that they're more aligned now.
Yes, it is. Okay, so you'll see this is the protection from abuse order, and the extent to which relief can be ordered is really reflected in this form as well, right? It's a very wordy, lots of boxes to check. As we get down to the relief section, we're talking about what is it that the court is ordering.
And so, sorry, Andrea, real quick, this is not the complaint.
This is not the complaint.
So this is not what the advocate would help. This is the actual order that the court would then issue if they decided to issue an order.
Yeah, this is the final order, right? So this is not the temporary order, it's the final protection order. And you'll note that they've got this language here. Violation of an order contained in paragraph A through J is always a class D crime. And sometimes it's a class C crime. And it may also be contempt of court. So that's when we go back and we're looking at that, right? It's this: don't commit any crimes against the person language, don't have any contact, don't go to their residence, don't repeatedly without reasonable cause stalk or follow, be around their place of employment or school. This is the provision around trying to deal with any revenge porn or concerns around revenge porn that's happened. The firearms pieces. We're going to move down here into the parental rights pieces. The parental rights pieces are enforceable by law enforcement. They fall within that bucket of category. So if you have someone who is failing to stay away from the children during times that they're not supposed to be around the children, that is a possible violation of the order that is got criminal consequences around it. And this piece around the pets, right? And then so when you get to the it is further ordered section, then we're talking about the things that really are only enforceable through civil contempt. These are the things that you're not really going to get a response from law enforcement or the criminal legal system around.
So I do have a question about that, Andrea, because I know that we've had some questions from some advocates in the past around like, okay, I see the parts of the order that are there, it's criminal conduct, it's a violation of protection order, it was a class D crime, possibly a class C, and then there's these sections that are just contempt of court, or these violations that are just contempt of court. And so, you know, if we're doing advocacy in the community and we're hearing from survivors that you know, they believe certain elements that should be charged as their violations of protection orders, like the defendant is, you know, A through J, you know, engaging in that conduct, but they don't believe that law enforcement is responding in the way that they should, or they're hearing about that consistently. Like, what kind of advice do you have, or sort of systems advocacy skills do you think that advocates can engage in to really like address some of these concerns that they may be hearing from victims?
I mean, I think as a baseline, it's important to know that this is, it's a mandatory arrest for law enforcement, right? So if we're going back to the protection order statute in section 4114, move down into subparagraph 5, a law enforcement officer shall arrest and take into custody when the law enforcement officer has probable cause to believe that there has been a criminal violation of an order issued under this chapter. So if you have right under section 4113, and that is the section that makes the violation of protection order a crime. So when you're, you know, in that circumstance and you have a plaintiff, you're working with a victim survivor who's has reported a violation to law enforcement of paragraphs A through J, and the law enforcement officer is saying, we're not going to do anything, like we gave him a warning, or we're going to issue a summons. That really is an opportunity for advocates to lean in and say, can you help me understand why? Because, you know, my understanding is that this particular portion of the order is a violation of a protection order if violated by the defendant, and that there's a requirement in our statutes that a person be actually arrested and taken into custody when there's probable cause to believe a violation occurred, and that there actually isn't discretion around that. So can you help me understand like why, like what the response is here and why? I think this is also a really interesting, again, opportunity for community-based advocates and folks from the district attorney's offices to collaborate and have communication, right? Or for there to be some advocacy, maybe with an assistant district attorney partner in that office, for advocates or victim witness advocates who might be in the position of being the first call a survivor makes around violations of a protection order if there's a criminal case also pending. You know, who do you talk to in the district attorney's office when you have questions about law enforcement response, and when law enforcement response isn't really aligning with what your understanding is of what's supposed to happen? I think that's an opportunity for advocacy, and I think you're doing a benefit to not only the survivor that you're working with, but also future survivors who are told to expect a certain level of response if a violation of a protection order happens in one of these category areas and it doesn't. I think it's also really important to lift up the seriousness of the patterned conduct there, and what that really means for a person to have gotten to the place where there is a protection order issued against them that they're then violating, right? Sometimes it's not uncommon for you to hear like, oh, it was just, you know, this small little contact violation, or, you know, there really was no harm in him parking outside her, I'm going to use gendered terms, parking outside her place of work for 3 hours yesterday. Who was really harmed by that? We've just explained that the defendant shouldn't do that anymore. And we think that's going to solve the issue, but really helping your law enforcement colleagues put that into context. Like, there had to be sufficient abuse to raise to the level of this person feeling like they had to go to court and get a court order to help them provide for their safety and stability. And then they had to actually go through the court process to have this order issued. And a defendant with full notice, right? Because you can't be arrested for violation of any of these orders if you don't have notice that the final order was issued. So this is an order that the defendant has knowledge of and is choosing not to abide by. And what level of risk does the totality of that circumstance actually have for the impacted person? And can we understand that? And can we talk about that? Because this is an order that a court has put in place that the defendant is violating. Does that answer your question?
Yeah, no, it does. I think it's so helpful for both systems and community-based advocates to understand, like, no, really, you can lean in. This is an opportunity to get curious, to engage, and to not just be thinking about the victim survivor in front of you, but to think about sort of what that law enforcement response can and is supposed to be moving forward. And I really appreciate you identifying that sort of collaborative opportunity between the DA's office and community-based advocates, because I'm not so certain that sort of approach has been happening as consistently as I think that it could. And I'm really hopeful that folks listening to this recording and of course the outcomes of this academy will lead to, again, better collaboration moving forward so that we can really enhance safety for victim survivors and ensure that our systems partners are, responding in the way that they're statutorily obligated to do.
And for sure, you don't want to approach your local law enforcement and tell them that they must make an arrest because the statute tells them to. I hope the takeaway is not that I'm telling you to go do that, but sort of to have that conversation and just be like, so, this is my understanding. What's your understanding? Can you help me understand? I'd really love to be well positioned to explain to the survivor I'm working with, like, how the system is responding differently than what she was expecting. And can you help me? Can you support me in sort of that need to support this person that I'm working with? And I think it's also okay to sort of raise it to the next level, right? So if you have an officer that you're working with, that you're responding with, I think it's okay to reach out to whoever whoever might be a friendly collaborator within that department and say, like, so I have this concern about this particular case. Like, is there someone I should talk to about that? Is there someone I could talk to about that within your law enforcement agency who might be able to take a look at the response here and, reflect back around whether or not that's really in accordance with the department response protocols and really, like, what is supposed to be happening. So I think there's a lot of different ways that you can sort of gently go forward and, sort of use the response to be not only an advocacy opportunity for the person that you're working with in the moment, but also to sort of build those relationships, have the good conversations, provide some education about why it's important to respond in a certain way for violations of a protection order, and how what seems like potentially a minimal or a nominal violation of the protection order really is an indicator of risk when you fold it into the totality of the circumstances.
Yeah. I'm curious too, how long are protection from abuse orders typically issued for?
Protection from abuse orders, final protection from abuse orders can be issued at whatever length of time a court determines appropriate, up to 2 years. Okay. So that first time a final protection order is issued in that docket number, the court has a hard cap of 2 years. Okay. That's a point of advocacy to work on with your local judges to help survivors support their own needs and talking to the court about sort of if they're asking for a 2-year order, why? If they're only, if they're asking, if you are in a court where the judge has a preference for a shorter order say, we have heard there are some judges who think a 6-month order ought to do it. Preparing the person that you're working with for that likely response, and also preparing them to maybe tease out for the court, I'm asking for this amount and here's why, is something that folks can help support survivors around. So first final order can only be issued for 2 years. There is an extension process. So if a person is coming up on that 2-year limit, or really the expiration at any point when their first final order is about to expire, they can file a motion to extend that order. They'd want to do that before the expiration of the order. And then the court can determine if a continued order is reasonably necessary to protect the person. And at that point, the court can order the next final order for as long as the court determines appropriate. So if it's a really egregious case, definitely seen protection orders issued for 50 years, for 20 years. It's not uncommon, and even sort of the, moderate to high level, to see courts issue them for 6 years.
I remember a case I worked on, a victim survivor, and she got an extension for 10 years. That was the longest I'd ever seen, but I have absolutely seen those extensions go for a long time as well.
And part of the advocacy there is really helping the court understand the impact on a litigant to need to come back to court on certain intervals. If we're all sitting here and we all have an understanding that this is going to be a long-term protection need, that it's appropriate for there to be long-term protections, let's just do that at the first extension, as opposed to requiring that person to come back every year, every 2 years for the next 10 years to do that. It's very sort of trauma inducing. And I think if you are working with a survivor in that situation, it's real important to connect them to an attorney who can help them make that argument, right? Because you're not going to be able to really stand with the survivor in court and advocate to the judge about why that's appropriate. Preparing the survivor to make that ask and help them understand what facts of their case might demonstrate, like what facts of their case you think demonstrate that they're at greatest risk, that they might want to talk about. But really getting them an attorney to help them make that argument is going to be key.
Yeah. And I was curious too about, earlier you had talked about a final order by consent and a final order with like findings of fact by the judge that a defendant committed abuse. Like, so what's the difference in the two? Are there benefits to either one? Are they different? What does that look like?
I think the most important thing to understand is, in terms of enforcement, there is no difference.
Okay.
A consent order has the same weight and enforceability as an order issued by a judge after a hearing. A final order is a final order, and they should all be treated the same in terms of if there's a violation or the strength of the order. There is no, if it's by consent, it has less teeth, right? Okay. Once the judge signs that order and it's official, it has the exact same enforcement strength, regardless of whether or not it was a hearing and a court made findings, or if during the court day for the hearing process, the parties came to an agreement about what that final order should look like. A difference that does have implications is if the court makes findings of abuse that can impact collateral proceedings. Most commonly, that's going to be family court proceedings, right? So if a court in a protection order context makes a finding that abuse has occurred, that's necessarily going to have to be something that the family court considers. The actual orders that the protection order court made, the relief that they issued as part of that protection order, will be entirely reconsidered by the family court. But the fact that there was a finding of abuse should move over and be considered by the family court as there is abuse in this relationship. The abuse finding doesn't get wound back.
It's an important point of advocacy, perhaps, when you're working with victim survivors and you're trying to navigate sort of the best process for the best approach during a final hearing, whether or not an order by agreement is the best approach, the safest option. If there are children, there's going to be ensuing sort of, like you said, collateral, court hearings regarding like family court. I think a really important point of advocacy for advocates to be able to talk about with victim survivors.
And I think I would be real cautious about how you talk to survivors around that point, and be careful not to sort of make it sound like a protection order hearing is the only place where a court could find abuse, because the family court, those issues would be up for findings in the family court as well. So if it really is the more trauma-informed approach, if the survivor can get the order that they want and need out of the protection order process through consent, that's often the way to go, because the abuse will able to be litigated in the family court. And that's, if there are questions around that, whether or not the protection order really should be litigated for that finding, that's another place where an attorney should really be looped in to help a survivor make those decisions, because the family court does have the ability to hear about the abuse to make that finding independently in family court. So it's not your only bite at the apple to have that abuse finding made in the protection order court.
That's very helpful. So the last question that I have, it's a little bit involved, but it's just really procedural, sort of, is the process. Just like, could you outline the process if you were talking to a victim survivor and they were like, how do I even go about filing for a temporary order? Sort of just start to finish.
So there's a packet of court forms that you're gonna have, and you can get them online, or you could walk into the courthouse and ask for the packet from the clerk. And it's going to be a fairly involved complaint where you lay out who you are, who the defendant is, if you have any children, sort of where are those children, what are any court orders that exist between the two of you, what's your relationship with this person. It will require you to sort of write a narrative to the court around what's been happening. You don't have to write every single thing that happened. You just have to write enough for a court to have an understanding that you're eligible for this order, and to sort of support the types of orders that you're asking the court for. But certainly you can note that this is not the extent to which you have been harmed by this person, that there are other examples of harm by this person. And you're going to file that with your local district court. So for plaintiffs, you can file it in the district court that you live in, and the district court that the defendant lives in, or wherever you may have sort of relocated to. You're going to file those forms. The court clerk is going to put you under oath, so that what you're telling the court is, it's a sworn statement. And then the clerk is going to take that packet of papers off to usually the district court judge. If there's not a district court judge available, a justice of the superior court can receive the paperwork too, but by and large, it's going to be a district court judge that's going to review the petition and is going to decide whether or not you have provided enough alleged conduct to qualify for an order. And then the judge is going to decide whether or not what you've alleged is justifying the issuance of that ex parte temporary order. And also they're going to decide what that order is going to look like. So it'll be important in the complaint for you to let the judge know if there are really any things that you need in the immediate in this temporary order, anything that's really important in the temporary order to ask for, and to also put on the complaint through checked boxes. The court has a lot of checked boxes to sort of help you think about what are the things that you might want to ask the court for. And so checking those boxes if there are certain types of relief that you want the court to be able to order and to flag for the court as part of the final hearing. Then the court clerk is going to send the information off to the relevant law enforcement agency for service on the defendant. So the plaintiff has no service obligations in a protection order case. There's also no cost. So there's no cost to file. There's no cost for service. The local law enforcement agency is responsible for moving that service on the defendant forward. As part of issuing the order, the court clerk is going to set a hearing date, and that hearing date should be within 21 days of the plaintiff filing the paperwork. It'll reflect as a summons for both parties to come into court to be heard on the protection order complaint. And you'll both just come back to court on that day. And on that day, there'll be an opportunity for both parties, usually through an advocate or through the court, to have a conversation to try and facilitate and find out if there's any agreement that can be reached and what that agreement might look like. If no agreement can be reached, the court will hold a testimonial hearing where the plaintiff will testify, any of the plaintiff's witnesses will testify. The court can take exhibits like photographs or, listen to audio recordings, those types of things. And then the defendant will have an opportunity to respond to the case that the plaintiff has put forward. The defendant might testify, the defendant might call witnesses, the defendant might have their own exhibits, and then ultimately a judge will need to decide whether or not they're finding by a preponderance standard, so it's just the 50+.1, that what the plaintiff's alleging, or at least some of what the plaintiff is alleging that qualifies under the protection order, has occurred, and what, if any, order should issue and what that order should look like. I think one thing it's important to really prepare survivors for in the hearing context is not only to tell the judge what has happened, but tell the judge what it is that you need. What are you wanting out of this order, right? A lot of times, plaintiffs, particularly plaintiffs without attorneys who are navigating this process pro se, will talk about what has happened in sometimes quite a lot of detail, and the judge will ask questions, and there's sometimes a back and forth. But then the judge is sort of left to then use their own judgment around what that person needs in terms of a final order. And sometimes judges will ask questions about that, and sometimes they won't. Sometimes they'll just issue the orders. So if there are particular orders that you need or concerns that a person has around things like visitation and contact with children or economic orders, it's important that the survivor really be prepared to talk to the court about that and explain what it is that they want and why. And that's certainly a place where advocates can be helpful in terms of supporting a survivor to know what to expect and to prepare to actually make those asks, right? If you're asking for child support, like, make sure they know there's a child support affidavit and documents that might be helpful for them to bring all ready to go into the court space. If they're asking for restitution for property damage or unpaid medical bills, to sort of bring in what they have and have that available. If they're asking for the defendant to pay a certain portion of the rent, to have whatever's available to them to bring it in to the extent that they can. And it's a short turnaround. It's a short window of time to do all these things. It can be a little bit overwhelming. Certainly, there's no requirement that you have external proof. A victim can always testify about anything, and the court can find their testimony credible. But to the extent that they have documents available to help support, to say, you don't even this is what I'm telling you, and here's how you can see that what I'm telling you is accurate, can really only help them to the extent that the court actually has the ability and willingness to engage with them on those issues.
Well, I'm very appreciative of you taking the time to walk through so many of these questions. I sort of open the floor if you have any other thoughts that you want to share with the advocates that are in the Maine Victim Assistance Academy before we finish up.
I might just say a thing about service on defendants, because there are sometimes where service on defendants of protection orders can be tricky. The protection order statute really requires a defendant to be personally served, right? So you can't mail it to the last known address, can't like drop it off at the house, at his mother's house where he's staying. It really does require personal service. And there are times where defendants, for a whole bunch of reasons, might avoid service. And just know that there is a court process in place to help survivors ask to be able to accomplish service in a different way. And so if you have a survivor who's gone back to court a couple of times on the hearing date and service has failed, right? There's no proof of service in the file, to start thinking about, with the survivor, how can we prove to the court that this person could have actual knowledge of the protection order in a different way, right? Do they have an active Facebook account? Do they respond to text messages on a known phone number? Those kind of things to help a survivor ask for the court to support alternative methods of service. And there has to be a court order around that. But that's a place sometimes that feels hard for survivors because they're having a hard time accomplishing service, and it's keeping them in the churn of coming back to court with some level of frequency, because there is this ex parte order hanging out there. Around that, if they have come back to court for, a handful of times, and we've gone a period of 5 or 6 months where service has been outstanding despite best efforts, and the survivor can actually talk about, like, I've been in touch with law enforcement and like, here's what they're telling me around service. It is not unheard of for the court to issue orders that will continue the case out for a much more a longer window of time, with a note on the order that when service is accomplished, the defendant can ask for that to be scheduled at an earlier date, right? I know I've certainly had cases where we said, we'd like to bump this out 6 months as opposed to coming back to court every 2 or 3 weeks, because the defendant appears to be avoiding service. And that's the information we have from law enforcement. And we'd like for plaintiff not to have to actually take a day off from work and get ramped up and ready to do this hearing, when we know that there's not likely to be service. And so there are some of these discretionary pieces that are really built in. And that's probably, again, going to be another opportunity to refer for representation, to help someone sort of make that argument. And that's not a horribly tall ask for an attorney to step in on and help a survivor make. And that could even be a limited appearance, right? I'm filing my appearance for the limited purpose of trying to help accomplish a court order around alternate service or a lengthier continuance and those sort of things. I would also say, would just note that with respect to child support and protection orders, we know that there's a very, very low proportion of final orders that have child support orders issued. It's much, much less than those protection from abuse cases where the parties have common children. And the feedback that we've gotten from the judicial branch around that really is the asks aren't being made. And so I think as advocates, appropriately working with a survivor around reasonable expectations. Like, if it's a hard court for a child support ask to be granted, supporting the survivor for the no to that request, but also making sure the survivor knows they have the ability to make the ask. And if it's something that they need, sort of encouraging to make the ask and to show up prepared to support the ask, can be really important, because that's the feedback that we've heard from the judicial branches. They're not seeing a high level of folks asking for child support. I think reasonable minds could differ on why that is, and that perhaps there are some historical denials from some of the district court judges that are driving a lack of asking. But the feedback has been, ask for it more.
Yeah, it feels like it's an important, a possible gap in advocacy, and certainly a point of advocacy for our community-based advocates, most likely, but perhaps also our systems-based advocates to really lean into and to explore that with victim survivors on a consistent basis, if that is a need that they've articulated.
Indeed.
Well, I'm very appreciative of you taking time to connect with me and to answer so many of the participants' questions around protection from abuse orders. We'll have this recording up for folks so they can look at it and reflect back on it. I think we've talked a lot about many elements of a protection from abuse order. There's many other things I'm sure we could discuss, but I'm hopeful that we've touched the surface on a lot of the key elements around advocacy related to protection from abuse orders. So thank you again so much, Andrea. And I hope everyone has a good day after you get to watch this.
Great. And please don't hesitate to reach out for technical assistance, right? If you're helping someone navigate and there are particularly tricky issues, please don't hesitate to reach out.
Thank you.